The courtroom on the 14th floor of the Daily Center in Chicago smelled like recycled air and old decisions. It was a Thursday in February, 9 in the morning, and I was the largest I had ever been in my life. Richard Sterling sat at the opposing table in a charcoal suit I recognized he had worn it the night we signed our prenuptial agreement 6 years ago. I had thought that was coincidence. Standing in the elevator that morning, alone, one hand pressed to the side of my stomach where our sun was shifting, I understood it was not coincidence at all. It was theater. Everything Richard did was theater. His attorneys had arranged themselves in a precise row of navy and gray. 3 of them. I had one, Miriam Vance, 58 years old, silver hair pulled back without ceremony, a woman who had never once raised her voice in a courtroom and had never needed to. Sloane Mercer sat in the gallery behind Richard, legs crossed, wearing winter white silk. My grandmother's sapphire earrings dangled from her ears, small oval drops, set in white gold, purchased at an estate sale in Savannah in 1962. I had worn them on my wedding day. I had not noticed they were gone from my jewelry box until this moment, looking at them on another woman's ears in the room where my marriage was being legally dissolved. Richard caught me looking. "Consider them a preview," he said, leaning slightly toward me, the way a man leans when he wants to be heard without being recorded, of how little you'll be taking home. He smiled after he said it. The kind of smile that has never once considered consequences. Miriam touched my wrist beneath the table. I looked forward. I kept my hands flat on my thighs and I breathed through my nose. What Richard Sterling did not know was that 3 weeks earlier, in a locked archive room on the 9th floor of his family's office building on Michigan Avenue, I had found the document his attorneys had forgotten existed. I grew up in Rockford, Illinois, in a house where the furnace broke every January and my mother worked 2 jobs and still managed to make Sunday dinner from scratch every week without complaint. She was an accountant. She kept every receipt, every statement, every tax document in manila folders organized by year and category, stacked in a metal cabinet in the hallway that she called the files. She died when I was 26, 11 months before I met Richard. Pancreatic cancer, diagnosed in October, gone by March. She left me $34,000 in savings, her 2009 Civic, and a small gold watch she had worn every day for 30 years, a Seiko, nothing valuable to anyone but me, with a worn leather band and her initials scratched faintly on the back. M.K. Margaret and Kowalski. I wore it to every important moment after she was gone. My bar exam. The day I was hired as an associate at Harman & Reed. The morning I first walked into Sterling Capital's offices to consult on a contracts dispute and met Richard across a conference table. I was a contracts attorney. Not a partner yet, but close. I billed $310 an hour, and I knew how to read a document the way my mother had taught me to read a balance sheet, slowly, completely, looking for what was missing as much as what was there. I had worked for 6 years to build a reputation in commercial litigation. I had turned down a position in New York that would have paid $40,000 more per year because my mother was sick and I was not leaving Illinois. I had missed a friend's wedding in Portugal because I was in the middle of a trial. I had eaten dinner alone at my desk so many times that the partners started leaving takeout menus in my inbox as a running joke. I was not a woman who needed rescuing. I was a woman who had simply stopped, for a while, paying attention to the right things. My mother's watch. I still wore it then. I would look down at it in the conference room that first day and think she would have had questions about this man. She would have been polite and she would have been watching. I was not watching closely enough. The early years with Richard were genuinely good. I want to say that clearly because it is true, and because the truth matters more than a clean story. He was funny in private, quietly funny. The kind of man who noticed absurdities before anyone else in the room and would lean over and say something in your ear that made you press your lips together to keep from laughing at the wrong moment. He read serious books and remembered what he read. He called his mother every Sunday. In the first year we were together, he drove 4 hours to Rockford with me to visit my mother's grave on the anniversary of her death, and he stood beside me in the cold without saying a single unnecessary word. I thought about that drive for a long time after everything fell apart. I still think about it. We married in September, a small ceremony in the garden of a friend's home in Lake Forest. 40 people. My mother's watch on my wrist, grandmother's earrings in my ears. Richard cried slightly during the vows, barely, just a tightening around his eyes and a single deep breath, and I had loved him more for trying to contain it. The shift was not dramatic. It never is, with people like Richard. It began with small corrections. A gentle redirect at a dinner party when I was telling a story he apparently found too long. A raised eyebrow when I ordered something he considered unsophisticated. Once, at his firm's spring gala, he introduced me to a senator as my wife, the former attorney, and when I said, quietly, on the way home, that I was still practicing, he said, "Of course, I just didn't want to make it complicated. I let it go." When I became pregnant, I reduced my hours at the firm. We had discussed this. It felt like a shared decision. Looking back, I understand I was the only one in that conversation who intended to revisit it. By the time I was 5 months along, Richard was traveling 4 days a week. His explanations were always reasonable: a board meeting in Dubai, a conference in London, a property negotiation in Miami. He sent photographs sometimes. Richard at dinner with colleagues. Richard at a golf course, squinting into the sun. I told myself that the distance was temporary, that it was the nature of his work, that I had known who he was when I married him. Then I found the hotel receipts. Not all at once. First one, tucked into the inner pocket of a blazer I was taking to the dry cleaner in November. Then a charge on the shared credit card statement that matched a week when he had told me he was in Vancouver. Then a second charge and a third, all at the same hotel in the River North neighborhood, all on weekdays, all for 2. He was not in Vancouver. He had been 14 minutes from our home. I did not say anything. Not yet. I had learned, from 6 years of contract law, that a piece of evidence you reveal too early is a piece of evidence that disappears. I started keeping a file in late November. I named it, in my computer's folder structure, Q4 Client Notes, which is exactly the kind of label no one opens without a specific reason to. The first document was a photograph of the blazer receipt, date-stamped, with the hotel name visible. The Kinsey Street Hotel, November 4th, a Tuesday. $347 for one night. Over the following 6 weeks, I added the credit card statements. I had always had access to those. Richard had never thought to change it and cross-reference the dates against his travel calendar, which his assistant had shared with me years ago for scheduling purposes and never revoked. 11 discrepancies between December and the end of January. 11 nights he had claimed to be in another city while charging a hotel room in Chicago. I hired a forensic accountant named Gerald Park, who worked out of a small office on Wacker Drive and came recommended by a colleague. At my old firm, Gerald was 61, meticulous, and entirely unbothered by people with money. He charged $4,500 for a preliminary review of Richard's disclosed financial statements and found, within 10 days, 3 shell company transfers that had reduced the documented value of Richard's stake in Sterling Capital by approximately $2.3 million. Transfers initiated in the months after I became pregnant. He handed me his summary across his desk and said, without drama, "This is fairly standard. They move assets before the filing." I kept my hands flat on my knees under the table so they would stay still. "Can it be traced?" I asked. "It already is," he said. Then I found the clause. I had gone to Richard's family office on a Wednesday afternoon in late January, ostensibly to retrieve documents related to our jointly filed taxes, a reason no one questioned. His father's estate attorney, a man named Holloway who had written most of the Sterling family's legal instruments over 30 years, was not in that day. His junior associate let me into the archive room without a second thought because I was still, technically, a Sterling. Article 12 of our prenuptial agreement. Subsection D, paragraph 3, in language so buried and so dry that even Richard's attorneys, reviewing the document years later for the divorce proceedings, had apparently not flagged it.in cases of documented marital infidelity on the part of the party of the first part, meaning Richard. The prenuptial agreement's asset protections were void in their entirety, and full equitable distribution would apply under Illinois law. It had been written by Holloway at the insistence of Richard's mother, Eleanor Sterling, who had watched her own husband conduct a 30-year affair with his secretary and had quietly, without anyone's knowledge, ensured her son's marital contracts contained a consequence. Eleanor had died 4 years ago. Richard had never read his own prenup completely. His attorneys had inherited the document and apparently assumed their predecessors had reviewed it thoroughly. I photographed every page. I sent the photographs to Miriam Vance from the parking garage at 5:37 that evening. Miriam called me at 6 the next morning. She said 3 words: "We have him. If you are in a marriage or a financial partnership and something feels wrong, do not wait for a confrontation to begin documenting. Start a file today. Not because you are certain something is wrong. Because certainty, when it finally comes, arrives faster than you expect, and the window to act with evidence is narrower than most people realize. Keep copies somewhere he cannot access, a cloud account in your name only, a folder at a trusted friend's house, a lawyer's office. The evidence you collect before you need it is the only evidence that cannot be taken from you." Miriam and I met 7 times between February and the divorce hearing. She was methodical in a way that reminded me of my mother, not warm, exactly, but completely present. The kind of person who makes you feel that the problem in front of her is the only thing in the world that matters to her right now. I did not tell Richard the first had found the clause. I did not tell anyone. I went home each evening and I cooked dinner and I answered Richard's texts about logistics, the name on the hospital forms, the pediatrician recommendation from his colleague's wife, and I said everything that was reasonable to say. And I did not say the thing I was thinking. Our housekeeper, Dora, who had worked for Richard since before we married, noticed something. She was 67, small and quiet, and she had been careful around me since the pregnancy, gentler than usual, bringing tea without being asked, staying later than her hours required. One morning in early February, she came into the kitchen while I was eating toast, and she looked at me for a moment, just looked, without speaking, and then she set a fresh cup of tea beside my plate and went back to folding laundry. She never said a word. She did not have to. My mother's watch was on the kitchen counter that morning. I had taken it off to wash my hands and forgotten to put it back. I looked at it sitting there beside the salt cellar, small, worn, slightly too loose on my wrist since the pregnancy had redistributed everything, and I thought she knew how to wait, too. I put the watch back on. I went upstairs. I slept better than I had in months. The courtroom on that Thursday morning was not full. Divorce proceedings at that level are rarely public spectacles. It was a judge, a clerk, Richard's 3 attorneys, Miriam and me, and 4 or 5 gallery observers, including Sloane, who had apparently been invited or had simply invited herself. Judge Harrison was 64, bespectacled, with the bearing of a man who found most arguments less interesting than the people making them. He had reviewed the initial filings and the prenuptial agreement and had shown, in his pre-hearing correspondence, no particular warmth toward either side. Richard's lead attorney, a man named Caldwell, presented their position first. It took 11 minutes. The prenuptial agreement was clear. I was entitled to $100,000 and the personal property I had brought into the marriage. He said clear 4 times. He said unambiguous twice. He slid a tabbed binder across to the judge's clerk with the practiced ease of a man who had done this many times. Richard sat with his hands loosely folded on the table. He looked at me once during Caldwell's presentation. He looked the way a man looks at something he has already packed up and left behind. Sloane, in the gallery, had stopped paying attention. She was looking at her phone. Miriam rose. She said, "Your Honor, before this court enforces the prenuptial agreement, we ask to address a condition precedent embedded in Article 12. The room did not change immediately. Caldwell made a small sound, not quite a word. Richard's second attorney turned toward Caldwell and said something beneath his breath. Richard himself was still for just a moment longer than he should have been. Then he turned to me. For the first time that morning, I looked directly back at him. Miriam submitted the full file. Gerald Park's forensic accounting summary, 47 pages, tabbed, cross-referenced. The credit card records. The hotel receipts. The shell company transfers. A notarized statement from the front desk supervisor at the Kinsey Street Hotel who had confirmed, with documentation, that Richard Sterling had checked in on 11 dates between November and January, always with the same companion. Always in a room booked under a Sterling Capital account. She submitted the text messages Richard had sent to Sloan from our shared phone plan. He had not known I could access those records until he was looking at them printed and tabbed in a courtroom binder. Then, she submitted the clause. Judge Harrison read it. He read it twice. He took off his glasses and set them on the documents and looked at Caldwell. Caldwell said, "Your Honor, we would request a continuance to review the document as part of the original filing." Mr. Caldwell, the judge said, "You've had it for 60 days. The refrigerator in the small anteroom adjacent to the courtroom hummed audibly. A clock on the wall above the clerk's desk clicked once. Richard's hand, resting on the binder in front of him, went completely still. The silence lasted perhaps 8 seconds. Then Miriam said, quietly, "Your Honor, under Article 12, subsection D, the prenuptials protections are void. We request full equitable distribution under Illinois law, including the recovery of the transferred assets documented in the forensic accounting summary." I looked at Richard. I said, the only thing I said aloud in that room all morning, in the same tone he had used 13 months ago when he told me no one would believe a pregnant woman with hormonal mood swings. "It will be painless. If you stop pretending you have leverage." His mouth opened. He closed it. Sloan, in the gallery, was no longer looking at her phone. The continuance Richard requested was granted for 2 weeks. It did not help him. Illinois equitable distribution applied to the full documented value of Richard's assets, including the recovered shell company transfers, put the marital estate at just under $34 million. Under the terms negotiated by Miriam over the following 6 weeks, I received $8.9 million, the Lincoln Park townhouse we had purchased together in 2021, and a structured payment of $4,200 per month in child support beginning at the birth of our son. The shell company transfers $2.3 million moved in anticipation of the divorce filing were ordered reversed by the court. Gerald Park's report was submitted as evidence of financial concealment, which the judge noted in his written order in language that was, for a legal document, unusually direct. Caldwell withdrew from the case. Richard hired new representation. The Kinsey Street Hotel records became part of the permanent court file. Richard did not look at me on the day the final order was signed. He sat at the opposite end of the table with his new attorneys, and he signed where he was told to sign, and he left without speaking. I do not know if he took Sloan. It was not a thing I thought about. I drove home on a Thursday afternoon in April, the windows down, the city moving past in the particular way it moves in early spring, that specific Chicago light, thin and watery and promising something. I was 3 weeks from my due date. My son was quiet in a way that felt like attention, like he was listening. When I got home, I sat at the kitchen table where I had eaten toast every morning for 4 years, and I took off my mother's watch, and I set it on the table in front of me. It sat there in the afternoon. Light. Small. Worn. The leather band soft from years of being worn. MAK on the back, in her handwriting scratched there by a jeweler in 1987 for a birthday she had never expected to make much of. She had kept every receipt. She had filed every document. She had taught me, without ever framing it as a lesson, that the most important protection a woman could build was not a lock on a door, but a record, a clear, complete, dated record of what was real. I put the watch back on. My son was born on a Sunday, 6 pounds and 14 ounces, at Northwestern Memorial Hospital. I named him Marcus. Middle name Allen, after no one Richard knew. I have thought about what that year cost me, the hours with Miriam, the months of saying nothing while knowing everything, the particular exhaustion of carrying a child and a secret in the same body at the same time. I have thought about what it would have felt like to react immediately, to confront Richard the night I found the first receipt, to have the loud and righteous fight I was entitled to have. I think it would have felt better for approximately 1 evening. And then the evidence would have disappeared. The accounts would have been restructured. The clause would have remained buried. I would have left with $100,000 and my grandmother's earrings on another woman's ears. Instead, I left with what was mine and with the particular quiet of a person who prepared and waited and trusted that the truth, documented carefully, does not need to be performed. My mother's watch still runs. A little slow, it loses about 2 minutes a week, and I have never had it adjusted. I like it that way. It keeps its own time. It always has. If this story stayed with you, if it gave you something you needed to hear today, share it with someone who might need it too. And if you want more stories about women who prepared, waited, and walked out with everything that was theirs, this channel is exactly where they live.